737DJ.
Jury, in this morning, I'd like to put on the record some of the discussions that we had back in my office yesterday afternoon, in particular regarding some instructions. First, I want to thank Judge Bruce Clerk, Mark Irwin, for helping us out on some instructions, which has certainly made it a little bit easier. I'm going to go down my list and then go to each side to find out whether they think what I'm saying is accurate. First, Mr. Buckaloo, on behalf of the defendant in the case, had raised the issue about whether jury instruction 7.10, which is person under the influence of alcohol or controlled substance, should be given in the preliminary instructions. Mr. Buckaloo also indicated that his preference, which is supported by a case called People versus Anderson, was to instead of giving the standard jury instruction of 7.10 to use paragraph 2 of MCL 768.21A, A is not in parentheses, sub 2. And I believe that we had agreement that we would give the instruction. It is listed as instruction 7.10, but the text of the instruction is in fact the second paragraph of 768.21A sub 2, and that is what is contained in the preliminary instruction. Mr. Bramble, do you agree that that was sort of a stipulation reached?
Yes, Your Honor.
And Mr. Buckaloo, do you agree?
I do, Your Honor.
All right. Next, in my proposed preliminary instructions, I had included both 7.09 and 7.11. Mr. Buckaloo pointed out correctly that in the use note of 7.9, it says, quote, when instructing prior to deliberation, use Michigan Criminal Jury Instruction 7.11. And so the current instructions remove 7. Let's see. Well, is this, let's see, is this correct? Right now we have 7.09 and no 7.11. Should it be the reverse?
No, that's correct.
Is that correct?
That's right.
All right. So everyone agrees then that that's appropriate as well. Mr. Bramble?
Yes, Your Honor.
And Mr. Buckley?
Yes.
All right. There was also a stipulation that the jury would not be invited to ask questions. Both sides expressed their preference in that regard. The court rule about questions specifically says may. It is discretionary with the court. And the court has no objection to the parties agreeing that they prefer not. Mr. Bramble, is that right, that you're on board with no questions from the jurors?
Yes, Your Honor.
And Mr. Buckaloo?
I am.
All right. The only other issues I was going to raise, I think we took care of in the back. I had some question about about Jamarion Lawhorn's parents testifying in immunity, but it sounds like that's already been taken care of. I wanted that to be cleared up before Mr. Buckaloo gave his opening, because he clearly needed to know some of that. Am I missing anything either side that we talked about yesterday, or that should be raised now before we call in the jury, give an oath, and then give preliminary instructions? Mr. Bramble, anything from your end?
No, Your Honor. Thank you.
Mr. Buckaloo?
Well, make a motion to sequester. I don't know if that's, suppose this is the time to do it.
All right, Mr. Bramble?
I would agree with you.
All right, Michigan Rule 11-6.15 does allow the court to sequester back witnesses in the case. I, of course, don't know what witnesses certain sides may be calling, but I'm going to assume that you'll let your fact witnesses understand that they cannot be present unless and until they are called to testify, after which they, of course, can then stay if there's no chance of being recalled. Do we have all witnesses sequestered as far as each side is concerned?
Yes, Your Honor.
All right. Mr. Buckaloo, is that accurate?
I believe so.
All right. Very good. Then let's show them the jury. charge made by the state of Michigan against one of your fellow citizens. Please don't open the books yet. I'll get to that in a moment. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict if you will please rise. Here is your oath. Raise your right hand. Each of you do solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court. So help you God. Please say I do. Thank you. Thank you very much, folks. Now, I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. A trial follows this procedure. Two, first the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does not call any witnesses, if the defense does call any witnesses, the prosecutor has the right to cross-examine. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. You have been given a written copy of the instructions I have just read to you. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for your use during deliberations. Now, folks, what we have handed to you is a binder. It has the instructions that I not only have just read, but all of the other instructions I'm going to read to you before we start the trial. Please understand, it's not as easy as some jurors think about, oh, we can just get a transcript, et cetera, et cetera. It's important that you keep attention, because in the world of video courtrooms, getting transcripts of testimony is not as easy as you may think. But nevertheless, they're there for you to look at if you think that it may help you throughout the case. Now, ladies and gentlemen, I will explain the elements of the crime charged and the elements of the defense of insanity, which is being raised in this case. The defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Michael Connor Verkerke, that is, that Michael Connor Verkerke died as a result of stab wounds. Second, that the defendant intended to kill Michael Connor Verkerke. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. Fifth, that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. One of the defenses that will be raised in this case is that the defendant was the law. Mental illness and legal insanity are not the same. A person can be mentally ill and still not be legally insane. Because of this, and because the law treats people who commit crimes differently depending on their mental state at the time of the crime, it is important for you to understand the legal meanings of mental illness, intellectual disability, and legal insanity. Mental illness is defined by law as a substantial disorder of thought or mood that significantly impairs judgment, behavior, capacity to recognize reality, or the ability to cope with the ordinary demands of life. Intellectual disability means significantly sub-average intellectual function that appeared before the defendant was 18 years old and impaired 2 or more of his adaptive skills. To be legally insane, a person must first be either mentally ill or intellectually disabled, as I have defined those conditions. But that is not enough. To be legally insane, the person must, because of his mental illness or intellectual disability, lack substantial capacity either to appreciate the nature and quality of the wrongfulness of his conduct or to conform his conduct to the requirements of the law. An individual who is under the influence of voluntarily consumed or injected alcohol or controlled substances at the time of his alleged offense is not considered to have been legally insane solely because of being under the influence of alcohol or controlled substances. You must judge the defendant's mental state at the time of the alleged crime. You may consider evidence about his mental condition before and after the crime, but only to help you judge his mental state at the time of the alleged crime. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? The questions that the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses' questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, if you wish, discuss the case with anyone. If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, the lawyers, or the witnesses about anything at all, even if it has nothing to do with the case. It is very important that you only get information about the case in court when you are acting as the jury and when the defendant, the lawyers, and I are all here. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Before recessing, I will instruct you. Remember, for the reasons I explained to you earlier, you must not read, listen to, or watch any news reports serving on this jury. So I hope to remember that every time I recess, I will give you that instruction to remind you. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Now that many jurors have easy access to information through handheld devices and other technology, jurors may be tempted to use these devices to learn more about some aspect of the case. But if a juror were to do this, it would harm the parties. The parties' attorneys would have no way of knowing that a juror has gotten outside information and would have no chance to object if that information was false, untrustworthy, or irrelevant. Remember, no matter how careful and conscientious news reporters, family members, friends, and other people outside the courtroom may be, information about the case from television, radio, the internet, and social media will inevitably be incomplete and could be incorrect. Please bear these things in mind as I read the following instructions. These restrictions apply from this moment until I discharge you from jury service. 1. You must decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. 2. This means that during the trial, you must not read, watch, or listen to news reports about the case, whether in newspapers, on television, on the radio, or on the internet. 3. You must also not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. 4. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, computers, cellular phones, or other electronic devices. 5. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, the court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. 6. Before your deliberations, you must not discuss this case with anyone, even your fellow jurors. After you begin deliberations, you should discuss the case with your fellow jurors, but you still must not discuss the case with anyone else until I discharge you from jury service. Until I have discharged you from your jury service, you must not share any information about the case by any means, including cellular phones or social media. If you discover that a juror has violated my instructions, report it to my clerk immediately. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. You must turn them over on your seat during recesses. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. In the 3-ring binder that each of you has, there is paper in the back and a pen or pencil, I'm not sure which, to allow you to take notes, so you should be equipped to be able to do that. You can see that we have chosen a jury of 14. After you have heard all the evidence and my instructions, we will draw lots to decide which 2 of you will be dismissed. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the end of the trial, I will give you detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After all the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. And I want to just give a little bit more explanation because I don't want you to be confused. Instructions that I've just given, which are in your binders, are what we call the preliminary instructions in the case. But by the end of the case, some of those instructions may have changed. So you can use the instructions throughout the trial that you have in your possession, but based upon the evidence that comes in, some may change, and that's why we'll give you a new set of instructions, the final instructions later in the case. It is important for each of you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. That completes the preliminary instructions in the case. I'm going to excuse you folks for what I think is just going to be about 5 minutes. When you come back, we will then begin the trial with opening statements from the lawyers. Please all rise. Seated. Mr. Frampton, I understand you have a motion.
Thank you, Your Honor. It's my understanding, I should actually re-preface this. Mr. Boogaloo has served a subpoena on Ms. Lawhorn. Whom I represent. And in response to that, we provided an affidavit to Mr. Boogaloo indicating that Ms. Lawhorn would not testify, that she would exercise the right to take the Fifth Amendment. It's my understanding that in response to that, the prosecutor intends to grant her use immunity for her testimony. I've not seen an application to that effect, but I assume that has or will be filed soon. The grants of immunity are governed by MCL 780.702 small a, and it indicates that once a prosecutor applies for immunity, the court can grant immunity if it finds that the immunity is in the interest of justice. Here we submit that the grant of immunity would not be in the interest of justice. Because I don't have an application, I'm going to make some assumptions, but I believe that the defense seeks Ms. Lawhorn's testimony to show that Ms. Lawhorn abused Jamarion. The government, I think, seeks her testimony to perhaps rebut that and say that she did not abuse Jamarion. On September 14, Ms. Lawhorn and I are scheduled for trial where the government alleges that she did abuse Jamarion. And a grant of immunity right now would basically allow the government to take a deposition of Ms. Lawhorn in advance of that trial. If immunity is not granted...
Let me ask you, if you believe that the government is going to argue that Ms. Lawhorn did not abuse Jamarion, doesn't that help you in a criminal case?
I think it may, but again, I'm not sure exactly what the government's going to do. I'm just going on some assumptions right now. Okay. If immunity is not granted, Ms. Lawhorn is deemed unavailable, and then her hearsay statements are deemed admissible. The government has a number of obviously, police reports that they've generated in
Was
this.
there a preliminary examination in the Ms. Lawhorn case?
Ms. Lawhorn waived it. So
So,
it's not.
in other words, there is no prior testimony?
There is no prior testimony, that's correct.
All right.
Yeah, I mean,
Yes.
I was under the impression that there was a prelim that was held.
Oh, I'm sorry, you're right, Ms. Lawhorn, there was a preliminary examination, she did not testify.
Oh, so
So
there
I'm
was a
sorry.
prelim, but
Yes.
she did not testify?
That's correct.
So
I'm sorry.
again, at least with respect to her, there's still no prior testimony subject to
That is correct,
cross-examination?
that is
Right.
correct,
Okay.
yes. In any event, there are a number of investigative reports with a number of statements in them that Ms. Lawhorn supposedly made that I'm sure Mr. Bukalu would like to use in Jamarion's defense. Ms. Lawhorn actually denies making many of those statements. Presumably, the government stands by its witnesses who said that she did make those statements. And if that's the case, then both the government and the defense are basically seeking to admit the statements that she made in the investigative reports. And if that's the case, then they both can get that information in that way, and it doesn't allow them to take a deposition of Ms. Lawhorn.
Well, they can get them in that way pursuant to a hearsay exception
Yes, Your Honor.
under 803?
Yes, Your Honor, that's my understanding.
Actually, under 804. Right, under 804, where the declarant is unavailable?
Yes.
You're suggesting it would come in under what? A statement against interest?
Yes, Your Honor.
All right, so your position is that I should not allow the grant of immunity?
Yes, my position is that it is not in the interest of justice to do so, because there is another way to get the statement in that presumably both the defense wants and the government stands behind. And on the other hand, the detriment to Ms. Lawhorn and in her case would be, or could be, great. So I would ask that the judge find that it is not in the interest of justice to grant the immunity request.
All right. Mr. Bramble?
Your Honor, if I may?
Please, Ms. Sykes.
Your Honor, we would oppose the, I'm going to turn this so I'm not kind of facing sideways. We believe that our offer of use immunity would preclude the assertion, obviously, of the any Fifth Amendment right, because we're offering the testimony, and we're not going to use that testimony against them, unless, of course, they would take a stand and say something different at some other point.
So I just want to be clear on all
Sure.
those points. So your position is that if you grant use immunity, you cannot use her testimony against her, but if she takes the stand in her criminal trial and testifies, you could use it to impeach?
Yes, if she would say an inconsistent statement, because then she's lying,
Okay.
she would be lying under oath at some point with respect to that. And Your Honor, with respect to the interests of justice, we need a fair trial here, and the jury has to hear everything. He talks about that we want to have statements in regarding the abuse that occurred to the defendant back in 2013. That's not at dispute in this case. But in 2014, Ms. Lawhorn made a number of statements that would be inconsistent and not against statements against her interests. So I guess the question becomes, how would we, when we present our case, or even ask for cross-examine Ms. Lawhorn, how are we going to get those hearsay statements in? Not Ms. Lawhorn, but another witness. Because it would be statements not against interest, but quite frankly, statements that we find very probative and relevant to this criminal case before the court. I guess what I'm saying is that there's dozens of statements. I'm not sure which statement they want in, but there's some statements she made that are clearly not against her interest, So they wouldn't come in under any exception when we tried to ask the question.
Help me understand. I mean, you're talking about trying to get statements like that as substantive evidence or as an impeachment?
Well, perhaps it depends when, I don't know what she would testify to. But if she would agree with what that, yes, she said, she made this statement in 2014, then it would be substantive. I suppose if she says, nope, I never made this statement, then perhaps it's impeachment. It depends on what her response would be to the question when presented. Your Honor, I just don't see how her rights are being affected in her trial for the child abuse that's coming up in a couple of weeks with respect to whatever she might say here today, given the fact that she has use immunity. There's just, quite frankly, no incrimination with respect to the Fifth Amendment, provided she tells the truth about whatever it is she's going to testify about.
Do you agree with Mr. Crampton, and I am not about to make a hearsay ruling when I don't have to, because we're not there yet, but do you agree with Mr. Crampton that at least it is arguable that if she were to not testify, you could presumably make an effort to get many of her statements into evidence through 804-3 that way?
Well, that's usually it says for a statement against interest. Some of the statements we want, Your Honor, are not statements against interest.
I understand. I just heard you explain that. I'm just asking whether you agree that at least with statements that she made that would have been against interest, arguably those would come in even if she didn't testify.
I would, yes. Obviously, any statement, I suppose against interest, that in that case, yes.
Right.
But of course, ours is that then we're precluded from getting the whole story to the jury.
Right.
And the interests of justice in this case are, quite frankly, as much to the defendant as it is to the state and, quite frankly, then to the Verkerke family.
All right, thank you.
Thank you.
Buffalo?
Your Honor, I think Mr. Crampton's motion is well-founded, and with respect to the last point that was made by the court and Ms. Seidel, assuming Ms. Lawhorn and, frankly, Mr. Harold, which would equally apply, assuming they are...
Harold's already pled guilty, correct?
He still has appeal rights, Your Honor.
Well, he does still have appeal rights.
He pled,
but it's not
actually,
as if he has a pending charge, right?
He pled no contest, but yes.
Okay.
Assuming they are declared unavailable for purposes of this discussion as a result of the Fifth Amendment claim, the statements made against interest would be actual testimony, not for impeachment purposes, but actual evidence pursuant to 804. Other statements made by...
I just want to be sure I follow. Is the scenario you're painting that an officer is now on the stand and that an officer is going to be asked about statements that Ms. Lawhorn made
to her,
and that made to the officer, and then there's an argument to be made that the officer can in fact say that, even though it would normally be hearsay, because if the declarant is unavailable, it might come in under 804-3.
Ms. Seidel talks about other statements that might be made to that aren't against interest, and I would suggest to the court at that point the impeachment rule would apply, and those statements could be brought in through that same witness for impeachment of the original statement made against interest. And if that's all she's looking for, she still has that available to her.
I just want to make sure I'm following your argument. You're saying that, pursuant to Rule 806, which allows you to attack and support the credibility of a declarant, because she would be a declarant, right? That they would be able to potentially impeach, even though she never testified. If I allow the hearsay in, they can then attack the declarant. Is that the argument?
That's the argument.
All right. Mr. Crampton?
Thank you, Your Honor. Just a couple of points to Ms. Seidel's argument. First, the statements can be used for, she indicated just if there was an inconsistent statement, that they could use that at Ms. Lawhorn's trial. That's not exactly true. They can be used for impeachment purposes, whatever those purposes are. In addition, I note that under 804, there's another exception, 7, which is a much broader exception. It says not a statement not specifically covered by any of the foregoing exceptions, but having equivalent circumstances, substantial. Yeah, it is. Right, and so it seems to me if there's a statement that Ms. Lawhorn made to the investigators in one context, there's a one, and that's allowed in, it seems to me all statements made to the same investigator would be allowed in under the same context. If the court deems that those are trustworthy statements, though, that is a way to get those in. And again, it's a way to get those in without having Ms. Lawhorn take the stand in this proceeding.
All right.
Thank you, Ron.
Thank you. Give me a moment to read the statute. Sort of gets into some questions I was asking yesterday when I acknowledged my own ignorance of the state law, because I know federal law better. But this actually does, the statute reads as if there has to be an application to the court. Now, that may be, more of a formal requirement than practice is, but I'm just pointing out that it does speak in terms of an application, and the application has to include certain things. But let me keep reading. It also requires sort of things you will get very way up. All questions of the witness and his or her answers shall be transcribed. A true and certified copy of the transcript shall be delivered to the witness as soon as practicable. So, we have to get that transcribed from our yes. Mr. Bramble, if I were to uphold your, for lack of a better term, granting of immunity, and if Mr. Buckaloo was to decide not to call him his law, would your side?
No, Your Honor.
Well, I think Mr. Crampton, states a lot of it is procedural, but I think Mr. Crampton states essentially accurately what the standard is. I'm looking at MCL 780.702 little a sub 3. If the court determines that it is in the interests of justice to grant immunity, the court shall enter an order granting immunity to the witness if the witness testifies truthfully or produces evidence in the investigation or proceeding concerning the investigation or subject of the proceeding. Mr. Bramble, I'm going to ask you to comply with the statute right now. First, are you making an application for the grant of immunity for Anita Lawhorn?
Yes, Your Honor.
Secondly, let's see here. I'm getting something here. Why is court? The application shall designate the person by name and address. You've designated It also indicates that the public official or agency shall include a verified statement setting forth the facts upon which the application is based. Could you state that now?
The facts upon which the application is based.
In other words, why are you asking the court to grant immunity in this?
Yes, Your Honor. What the defense wants is basically to allow statements against penal interest involving Anita Lawhorn. We want to get statements in, and it revolves around the alleged incidents that occurred in 2013. We're not contesting that there was physical abuse at that time. However, Ms. Lawhorn makes an additional number of statements indicating that the abuse ended then. There had not been any abuse up until the August 4 of 2014 when this homicide occurred. So, and those statements wouldn't be against penal interest. And we want to collect all those statements so the jury has a full view of everything Ms. Lawhorn.
Examination, you would not be calling her as a witness to try to elicit those statements. First of all, there's a question as to whether it would be hearsay if it was your witness anyway. But in any event, I understand that correctly?
Yes, I can see it.
Thank you. Mr. Buckle?
Well, it's assuming she would be called because of the grant of immunity.
And you understand, of course, the grant of immunity doesn't make you call her.
I understand that.
Okay.
But if I do call her, I very well might be calling her as an adverse witness, in which case I would be essentially cross-examining her to begin with. I certainly would be able to use leading questions if the court granted that. Because at that point, she's as much an adverse witness as anyone, because it's against her, it's against what some of the statements she's made as referenced by Mr. Bramble.
I'll give you one last crack at it, Mr. Cranford.
Thank you, Your Honor. Well, hearing Mr. Bramble's statements that they want her to testify abuse that took place after the 2013 incident.
Or lack of abuse.
Or lack of them, yes. I think it's well known that Jamarion left and went to live with his father for about a month of that period, and there was only one more month between when he came home and this incident. And there, as far as I know, has never been any allegation of abuse during that time period. We've never seen any in any report. We've never seen any discussed by anybody. Now, basically, they're asking them.
Well, what about the time period after he returned from New York?
That's what I'm saying.
Well, I understand, but they're suggesting. Look, I don't see these reports. I don't know what's in these reports, but they're suggesting that she was making statements denying abuse at the time that she would have had firsthand knowledge. I presume. I mean, she can't testify as to what's going on with the kids in New York, right? So they're suggesting that she may have been making that abuse was not occurring after he returns from New York, but prior to this incident.
That I think is correct. I think, Your Honor, obviously I've seen all the reports, and there's not a single allegation of any abuse after he returned from New York. There's no allegations by the government that there was any abuse during that time period.
Well, let me ask the government, and I went to Mr. Bramble, you were the one who argued the motion this side. It doesn't matter to me. I mean, first of all, let me just ask a factual question. Are you, I'm asking for an informal proffer. Do you anticipate presenting evidence that there was physical abuse of Jamarion after his return from New York?
No. In fact, we are wanting to completely set the record straight that based on the evidence we have, no abuse occurred after he came back to New York. The reason it's I believe, and the reason I think they want the Ms. Lawhorn to testify is in Dr. Rao's report, and if you're asking me for offer of proof, Dr. Rao's report talks about abuse that happened the day before this homicide, which is all new information, and so to allow somebody to get on the stand and preclude us from saying, you said no abuse happened after that, and then be able to say, well, maybe some did without it, and that's part of their defense. At least that's my understanding. That would be part of their defense and the insanity part of this as well, to show why he did what he did. Well, the evidence doesn't, we would not be given a complete picture to the jury if we weren't allowed to have statements contrary to physical abuse happening.
But again, you wouldn't be intending to call Ms. Lawhorn.
Absolutely
Mr. Buckler
not.
doesn't.
We absolutely.
So if Mr. Buckler doesn't call Ms. Lawhorn, you're not going to be able to elicit that on your own.
Not through some of the other witnesses that we might have been able to elicit it.
Understood, but not from Ms. Lawhorn.
Correct, or even from a police officer or a CPS worker.
Obviously, I'm not privy to Dr. Brow's report,
Understood.
so I haven't seen that. That's the first I've heard of it. I would certainly think that if Ms. Lawhorn were to testify, she should be at least provided that portion of the report prior to her testimony. But again, I think that, that there's really no reason for the grant of, or that there may be some reason for the grant of immunity, but I still think the interests of justice outweigh the request for the grant of immunity, because in this case, I don't think anybody, either side, is contesting the statements that were made in the police report. So now you're talking about simply a 1 month period where there are no allegations of it, at least in any of the reports, and obviously that's not good for Mr. Bukalu. It may be good for the government, but it certainly wouldn't be good for the government to elicit that out of Dr. Rao's report either.
All right. Last word, Mr. Buckler.
Just in the interest of setting the record straight, there will be an offer. I'll make an offer proof right now that Ms. Leonard at CPS will testify that Ms. Lawhorn stated for the week prior to this incident, they threatened him with abuse every day, both she and Mr. Harold.
Okay, so but I heard you say threatened, not actually abused, so you're making that distinction.
To the extent it's relevant.
All right. Okay. All right. Thank you very much. It's an interesting issue. The court does find that it is in the best interest of justice to grant immunity to Ms. Lawhorn. That does not require the defense to call Ms. Lawhorn. I just heard an assertion by the people that if the defendant doesn't call Ms. Lawhorn, they're not going to call Ms. Lawhorn. So in many ways, it means that the decision has to be made by the defendant. Now, that's this case. I also am very appreciative of the fact that Ms. Lawhorn has a pending, I think it's a child abuse charge, I'm not certain of that, and a trial coming up on September 14th. But I'm satisfied that with the grant of use immunity, the people cannot use any of her words against her in that prosecution. I suppose the aspect of whether or not they can impeach if she takes the stand is similar to Harris versus New York and all those other constitutional cases and search and confession cases where even if they were illegally obtained, you can still use them to impeach because the system puts a premium on truth-telling, and there's nothing I can do about that. But I do believe that the grant of immunity sufficiently protects Ms. Lawhorn with respect to her case. Therefore, I will grant the application for immunity and allow the defendant to call Ms. Lawhorn. Thank you, Mr. Grant.
Your Honor, one last housekeeping matter. Obviously, Ms. Lawhorn is entitled to representation by counsel when she testifies, so it's a statute. I've got obviously other court hearings and things. If we can just simply, I asked Mr. Bukalu to stay in touch with me and perhaps try to schedule it so that it can be
That's
attended.
fair. I should tell you that we have a number of, as usual in a trial, we have a number of sort of scheduling issues. We have an expert coming in from Detroit. Mr. Buckler wants to call somebody who he subpoenaed, who was previously subpoenaed in another court. So it's a little unclear as to how this is going to go. Mr. Buckler, I assume that I can count on you to keep Mr. Franklin apprised as much as you can so that he's not spending a lot of extra time here.
Absolutely, and obviously I'm going to be speaking to Mr. Adams, who represents Mr. Harold as well. I assume he has the same right, even though he did plead no contest already to an issue.
Mr. Adams isn't here, so
I understand that, but I've been told that he's going to be given a grant of immunity. I suppose we should have an application for that as well, if that's going to take place.
Again, Mr. Buckley, you don't represent Mr. Harold, and I'm not going to tell the prosecutor's office how to proceed. I've already made them essentially comply with the statute. Implicit in that was a suggestion that maybe they should have done that originally.
Your Honor, the only reason why I'm bringing it up is that the law is very clear that I'm not supposed to put someone on the stand who I think may plead the Fifth Amendment if I know that they're going to do that.
Again, and as we discussed at pre-trial conference a while ago, before I would allow Mr. Harold to testify, I would hold a pre-trial evidentiary hearing, and I would find out if he was going to invoke his Fifth Amendment privilege, and then make a decision then, but it's not likely I'd allow him to testify. That I get, and that is entirely a proper role for you. I'm not trying to be flip here, but you don't represent Mr. Harold.
Oh, I know.
Brandon doesn't represent Mr. Harold. So right now, that's not conforming. If Mr. Adams brings a similar motion, then of course I'll hear it at that time.
And of course, he's already submitted a similar affidavit. So I'm just saying I'm going to be giving him the same courtesy.
Fair enough. Fair enough. Again, thank you, Mr.
The one other thing, Your Honor, is Ms. Lawhorn entitled to at least that portion of Dr. Rao's report where the allegations made?
Well, I mean, first of all, you got a copy of Dr. Rao's report, don't you?
Oh, you're talking, yes. Sorry.
And I'm not aware of there being a protective order that does not permit Mr. Buckley to show that to any of his witnesses. Would you agree, Mr. Bramble?
I can't think of any reason why you couldn't.
I can't either. So if Mr. Brandon requests that his client get a copy of Dr. Rao's report, that's not going to be an issue, is it?
No.
All right, fair enough.
Thank you.
And I will comply with the statute. If Ms. Lawhorn is called, I will certainly make sure that the transcription be made of the testimony at our responsibility.
Thank you, Your Honor.
Thank you very much. Anything else then before we bring the jury back?
I'm sorry.
Anything else before we bring the jury back? I mean, I can give you folks just a couple of minutes if you want to have a discussion.
I would appreciate that.
Sure. I'll explain to the jury that 5 minutes is now 5 minutes.
An accurate statement.
Yes.